Alrighty. Today I'm going to go over some of the actual documentation from the Mason's Manual that I've posted in the E-Clause group. I've actually taken that PDF and broken it down. So those of you who have downloaded it and want to go through it in real time, you'll be able to, open that PDF up and refer back to this as we go along. So that said, let me get right into that. And that is this bad rascal right here. Now, in the Mason's Manual, the actual, due process of law, this actually has nothing to do with the bar. This has nothing to do, or very little to do, with the court. One of the things that we need to do in our remonstrance is to go through and highlight as many times as the court has said, hey, government, you can't do that, right? Pick a that. So whether it is putting people in jail for money or whether it is some other form of constitutional violation, this is where you make those constitutional arguments. And one of the first things that you need to know about how to make those arguments is you're going to have to unlearn some of what you've learned litigating in court. And this is where it becomes complicated because, myself included, I became so entrenched in this ridiculousness of this overly burdensome, monopoly bar crap, right? So what we're doing is we're actually saying, well, we already know that the court's not going to do its job because the bar's basic mission statement to overthrow the Constitution, the Declaration of Independence, and our succession of law is to deny justice. And by denying justice, they're therefore denying liberty. So, therefore, we can take what they've said in history and use it against them. In other words, like in the Miranda warnings, anything you say can and will be used against you. This is the exact process on how to do that. So when we talk about walking into Congress, now knowing that some of the bad actors who are trying to implement their various agendas, call it Agenda 21 or 2030 or whatever number it is, now, they are going to be intertwined. Chances are they're bar members. So what we can do in assembling the quorum is we say, okay, because these actors are technically in violation of the original 13th Amendment, they don't even have a voice in this quorum, right? This is how we go around these actors. There's always a bigger fish because chances are the people that are remaining in the quorum, whether they're Republican, Democrat, Libertarian, Martian, it doesn't matter. Chances are they're going to have somebody either in their family or somebody that they know has been through something like this, and two things are going to happen. Number one, they're going to go back and they're going to revisit those conversations they've already had, and they're going to start to take different looks at this stuff. Why? Because we're doing things actually managing the republic, which is technically speaking our job. And that's why these attorneys come out and say, oh, no, you can't do that. You can't do that. You can't do that. Really, you have to prove that I can't. And the thing that they don't like about me is the fact that I have a standing in Congress and through the executive branch, through the various things that I put up on the screen, that fiduciary license, and of course my notary oath of office and all those other things. So I said, okay, well, I'm going to take my emoluments, right, my privileges and like that, and I'm going to battle throughout this process. I just happen to know the process better than a lot of the bad actors that I'm fighting, which is one of the reasons why I'm teaching you guys this stuff. So let's jump into it. And where we go from here is when we talk about parliamentary law and rules. Okay, well, rules are things that govern the procedure, the process, right? That's basically to maintain some level of decorum, something, you know, so in other words, you don't have a bunch of people standing there yelling and screaming at the same time, which is not uncommon, by the way, but anyway. During the rule-making process, when you're convening your quorum, this is the part where you say, anybody who's litigated in court basically has a bar card, right? This is where we use it against them. You are excluded from the quorum because we also know of the conflicts of interest that this process is going to present to you. And therefore, however you feel about it personally or whatever, you don't fall within the, you're going to have to make a decision, ultimately speaking. Are you a good or are you a bad actor? In other words, are you part of the cleanup team or are you part of the cover-up team? And we'll talk about that later. But in the here and the now, when assembling your quorum, this is getting to know who the people in Congress are, who has bar cards and who doesn't, right? So you're going to serve everybody, whether they have a bar card or whether they don't. And this is kind of what I metaphorically call kicking the door open, which is what I do with a parliamentary inquiry. Excuse me. So as far as going down through this, there is a necessity for rules of procedure. As I said, there needs to be a decorum. There needs to be an actual lawful process, some form of logic and reason to follow as you go through your presentation. Now, let's go into the constitutional rules governing procedure, right? This is what I was just talking about with, you want to make constitutional arguments. The Court of Justice, which is Congress, is the actual place to make those arguments, okay? You want to challenge the validity or non-validity of a statute or a rule or whatever, that you take to court, okay? That's one of the reasons why most are almost 90, I think it was 95 or 98%, I think what it was. We had looked at this once. Title 42 cases are dismissed. And it's not just because you are, technically speaking, not a bar card carrying member, even though we know that rule is not lawful. That rule is them acting as a monopoly in a declared act of tyranny, where they have inserted themselves with the authority to legislate for us in all cases whatsoever, blah, 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 blah. That's why I use the Declaration of Independence as the authoritative document. In every one of these I do. So I just go through and pick out which declared acts of tyranny or which maxims of law or which cases of things that have already been adjudicated that seem to best fit that particular segment of the argument that I'm making. This is how I constructed the actual negative nexus itself. And I'll do that. I'll go through how to do that in another live stream. But in the here and the now, what are such things as constitutional rules governing procedure? Well, and again, I believe I have done that in my SCOTUS question, where I went down through and I said, look, there's 10 criteria that you need to follow. As a matter of fact, I'll go ahead and pull that up so I can read down through those with you as we do this. And that thing is called, SCOTUS question. And here it comes. Share. Here we go. And what are those 10 criteria? So let's go down to those and find out what those are. And in the book, the new version, which is not the one that's online, the 2010 version, that's why this, I'm going to go over this with you. It is in the old version, but I just don't have it. I don't have it bookmarked, but we have to go down through and decide, number one, what's the subject matter? What is the jurisdiction? Okay, this is where it gets really difficult, because a lot of these cases have already been adjudicated through family court. There's the potential question of double jeopardy. Okay, so that's one of the reasons why I went after fraud, because going all the way back to before the republic was a republic, fraud vitiates everything. So when you look at a lawyer and or an attorney, and you tell an attorney you're full of crap, every bit of what you're pulling is a scam, right? It's a sham. It's a shit show. It's crap made up. And here's how I know that. That's when they really started to get, we'll just say indignant with me. And so one of the things we have to do is we have to go in and say, as part of jurisdiction, it cannot be assumed. We know that. It must be granted. These groups sometimes assume powers they do not have. Now, what's your check and your balance on maintaining a level of standing in the quorum? Okay, this is where John goes into when we talk about this on the show. He wants to make his presentation. Why? Because nobody knows his case like he does, which goes to the maxim of law. Everyone is the manager and disposer of his own matters. So there's your standing. It actually comes from a maxim of law. And it all depends on how you articulate this stuff as you go through it. So in order to state, look, if there's going to be any kind of jurisdiction, I'm going to be the one presenting this for two reasons. Number one, nobody knows it like I do. And number two, in the interest of time, right? This is one of those things that you can do to basically kind of sell yourself in that, look, I'm not here to beat you up. I'm not here to take up a bunch of your time, make you have to go through something that you either may or may not understand. I'm just going to go down through it with you, and we're going to make the collective decision, which goes into number two. There must be a meeting of the decision-making group, okay? And this part right here is where you go through and you kind of go over this is the reason that I prepare the documents the way I do. This would be where I would read the preface of each one of my documents, okay, to the quorum once it's assembled. And that's just kind of a brief reasoning as to why we're here, what we're going to discuss, and, moving forward, if this is not something you feel qualified to do, kind of like speak up or forever hold your peace, right? And that said, when authority is vested in the group collectively and are not merely to the individual members of the group, to make a decision, the group must meet and make up its collective mind, okay? Now, keeping in mind that presentation is only one small part of this process. In order to come to the resolution, okay, there's sometimes going to be a series of meetings. So again, knowing this and having done this more than a few times throughout my career, I wanted to go through and give the benefit of how many times I've done this, how many different quorums I've participated in, how many different versions of subject matter I've participated in, and the processes that I've followed what we call in the private sector loss prevention, which is the thing that manages the mechanism, the spine that manages each of the corporations. So when we go and we give our reports, we are actually following this process, whether we even realized it or not. That's why when I looked at it, I'm like, holy crap, this is my job description. I remember this. So it was a, finding the word emoluments, which is kind of where I always say where the rubber meets the road, was just sort of a happenstance because of the circumstances that around my case, which I won't bore you to death with. One of the other things that you have to do would cover is going back to what I said about serving all the members. Now, whether they're going to be in the quorum or not is irrelevant. A proper notice of the meeting must be given to all the members of the group, right? That's actually number 3. That's why I said it's just me doing business as I've always done it. And we decide collectively who is going to sit in on this particular piece of subject matter and who would probably, number one, either wouldn't have a clue and would be a hindrance anyway, or somebody that might have an interest in this and might, some financial interest or other form of interest that would hinder their ability to remain neutral. Okay. So I'm going to start cutting this back a little bit so I don't go into a whole lot of extra time. There must be a quorum present at the meeting. Okay. The quorum is as defined in Black's Law. I took the liberty of actually defining that as it is in parliamentary law, because that's actually what we're talking about is parliamentary law. The group, the Congress, the people that, what I refer to in the private sector is the board of directors and the CEO. Sometimes the CEO sits in, sometimes he or she doesn't. But it just depends on what we're discussing and if there's going to be any long-term investment or long-term potential liabilities, whatever the action is we were taking. I used the one of the environmental cleanup that we did in one of the markets that I worked. We went around and collected a bunch of used batteries and sent them back to Johnson Control for recycling. That was a long-term investment, but turned out it was well worth it in the end because that process solved a myriad of other problems. And I won't bore you with how all that worked. But the point is we ended up in saving ourselves a couple of $1 million company-wide because of what we did. So again, that is knowing the difference between the cause versus the effect. When we did this, we didn't realize, we knew what the cause was. The cause was we had an environmental problem. The long-term effects that turned into benefits to the company was just something that was like, hey, cool, this is what we get for doing it right, right? So that said, there must be a question before the group upon which it can make a decision. Well, what's the question? And the question is, if we're talking about the construction of government, right? Government says, oh, yeah, you can't do that, pick of that. So then my question is, in the parliamentary process, if the court said you can't do it, why are we still paying for those emoluments, right? This goes to managing the republic, right? This is up to us to do this. So because technically speaking, family law is just more of that bar SMU, which you guys I'm sure know what SMU means by now. Shit made up. So from now on, that's what SMU means. I walked in and said, look, I filed, in my case, in the federal court. The federal court dismissed it, basically kind of gave me the scathing kiss my butt. We don't want to hear you. Get out of here. You're an idiot because you're not part of our club. Well, guess what happened when I made the reports back to Congress? That kind of pissed them off a little bit because what the judges were, or what these bar members were telling Congress and what I actually reported was two different things. And, knowing that reason in law is the perfect equity, that's a maxim of law. There was nobody hurt, there was nobody dead, and the subject matter at hand was a fraud upon the court. Now, wait a minute. During the Judiciary Act of 1789, we vested authority to maintain the integrity of the court and lawful process in these judges, right? So we call those the judicial canons, canon law, right? So here's your box, judges. This is what you're supposed to be doing, right? Now, as far as the rest of who's calling the balls and strikes is concerned, and administrative law and how that literally devolved back into a third world country, well, again, that's neither here nor there. The point is even the court has said, government, you can't do that. And I said, basically, if the federal court does not want to participate in family law cases, they don't even recognize the practice as lawful. And again, this is me following my process, stating, here's what the judges said with their basic kiss my butt, knowing that the federal court has said children and are of the liberty interest. So if they're going to deny justice, by definition, they're denying liberty. And you don't have to be a judge to know that you can't do that, because securing the blessings of liberty is part of the preamble to the Constitution. So this is, again, the management mechanism. And this is why I want to teach you guys this stuff. So that said, we're going to move into number 6. There must be an opportunity to debate the question. Okay, now let me go back into debating, because that's actually covered in the Mason's Manual. So I'm going to jump around just a little bit here and go to that debating what can be debated and what can't. So let's go down to debates. Here it is. What is debatable? And it outlines it in this section, which is page 40 of 322 of this Mason's Manual, right? So it goes through in these sections under what is a debate, chapter 10, the purpose of the debate, okay? What motions are debatable, right? In other words, if I'm going to make a motion as a request, then that's debatable. If I'm serving you a notice, that's not debatable. If I'm serving you a memorandum of law on a decision that's already been made, that's not debatable. Okay, so those are some of the examples, and this section goes through a lot of what those are. Now, here's it under page 41, number 2. The following motions are not debatable. Okay, and it goes through what those are. Adjourn unqualified. Call of the House. That's a motion that's not debatable. Why? Because we have the right to redress. So they can't even debate that. Here's one. Something that's not debatable. A parliamentary inquiry. Right? In other words, this is not me here asking you. This is me here telling you that this is what has already happened. So when it comes to, like we say on the show, family rights and civil rights don't have a damn thing in the world to do with the establishment, support, or management of government, right? Like I said, if you're going to walk and knock on the door, knock on the door. I don't knock on the door. I kick the damn door open. So this is what I said. This is knowing how to do this and do it properly. So you can go down the list of the things that are not debatable, and here is the entire list of things that are not even debatable, right? These are things that you can prove on paper or through some other form that have already happened. It's stuff that's already in the past. You can't change it. You can't pull spit out of the ocean. It's just not going to happen, right? So this is when I do business. These are called certainties. Managing private sector emoluments, this is the realm that I've always worked in, right? scientifically proven. -1 times -1 is 1, right? That's scientifically proven. That is not crap made up. It is what it is. And it's based on actually 2 maxims of law. So this is what I said. When I constructed this thing, I knew it had to be airtight. It had to be provable beyond reasonable doubt because of the jury, the quorum, right? That's a form of a jury. It's just called a quorum or a Congress, right? So let me go back to the actual list of questions of, here we go. The question must be decided taking a vote. Okay. Well, because these things are already decided, the court has already said children are of a liberty interest. That means family law is SMU, right? So why do we even have to take a vote to undo something that doesn't belong there anyway? Which is, again, part of my reason why I went with the parliamentary inquiry. I'm not here to debate you. I'm here to tell you what the judges have already said. So quit trying to rewrite your word salad and all of your crap made up, because it ain't going to fly. And here's how I know it ain't going to fly. You've been doing this crap to us for so long, I can go down the Declaration of Independence declared acts of tyranny and point to every one you're using as a checklist, bar members, right? And, oh, along the way, since I've started this process that in my company that I call E-Clause, provide for the common defense, that's not only lawful, it is a duty as written in the preamble. So don't tell me I can't do that. You have to prove that I can't do that, you jackwagon. That's why I said, I'll see you in Congress. So there must be a majority vote. Now, this is where it gets sticky with this political party crap, right? These political parties will tell you, oh, well, Republicans are of controlling, the Democrats are of controlling. That is wrong. In a quorum, the majority is of, say you've got 50 people in the quorum. The majority is 26 of the 50. And I don't care if you're Republican, Democrat, Martian, Libertarian, drunken, doesn't matter. If you're part of that if you're part of that 50 people quorum, the majority of the vote of 26 of the 50 is going to decide how it's going to be handled, right? So the other 24 can jump up and down and, whine and cry and bitch and complain all they want. Here was the other thing, part of the argument that made it even more ironclad was number 9, okay? Because one of the things that I'm very good at is finding where's the fraud, right? Where's the trickery or the deception? Well, not enforcing perjury statutes is a form of trickery or deception, at the very least. It doesn't even necessarily have to be fraud. But trickery or deception are also included in this same stipulation. So if there's trickery or deception, either or both does, in the end, constitute fraud, no matter how you slice it. It is what it is. And that goes all the way back to a case that was actually decided, was before Marbury v. Madison in 1803. Don't remember it off the top of my head, but it's in the paperwork. So, which kind of actually led to number 10, to be valid, any action or decision of a body must not violate any applicable law or constitutional provision. So them enacting family court was never lawful. Was never lawful. Why? Because how they've deconstructed the court or the Constitution, weakened the Constitution. Not only does it not provide for constitutional provisions or protections, right? This is where the constitutional argument is made, right here at number 10. And I've given a couple of examples of this. Also, spoiler alert, Nate and I discussed it, and we are about to come out and do one of these, and he and I will be doing this, just the two of us, where we're going to do a complete document dump of the Texas case from beginning to end. Where we started in federal court, what the judge said in federal court, and why that cleared his name, and where that's led us to the state court, and why we were granted a mandated standing. So, in other words, you'll be able to see that it was this process didn't just work for me; it worked for one of my clients who's been working with me since we started this. So, this is what I said. This was more or less me pointing out that, yeah, dude, I know who these bar actors are, and you and I have the same problem, Congress. Those lobbying people, you know, the ones that come in and they look around and they start to say, oh, yeah, John Schmuckatelli over there from, you know, whatever the district is, he was walking down the hall and he had his arm around that intern over there, and I'm going to take a picture of that and blackmail him with it. So if he doesn't vote the way I want him to, I'm going to manipulate his ass into doing what I want him to do. And that's exactly what's been going on. I mean, let's just call this spade a spade. You know it, I know it. By going in there, informing them that we know it, telling them, don't worry about it. If these actors want to come out in the media and do this smear campaign crap, dude, you've got Nancy Pelosi admitting on national television what a smear campaign is. So trust me, she doesn't, not only does she not scare me, she's more annoying to me than anything else. So let's go back to constitutional rules governing procedure. Okay. Legislative procedure is controlled by constitutional provisions. Again, this is where you make your constitutional arguments. You make them in Congress, knowing full well that you're going to be denied cert in the Supreme Court anyway for all of the bar's crap made up. And that denial grants you standing in Congress. So as soon as they tell you no, you take that decision. And believe it or not, the more scathing the decision that they throw you out of the courtroom with actually works in your favor in Congress. Because when you go in there and you say, look, here was what I went in there to do, right? I had business with the court because that's what we have collectively decided over 200 years. And here's what here was their reaction. Is this even logical or reasonable? What part of the canons did they follow to even get here? Right? So that's why I said you have to go through it, and you have to do it logically, you have to do it reasonably, and you have to say, well, yeah, they have to make them come to the conclusion of, oh, yeah, there's no reason for them to treat you like that. No. So again, constitutional requirements concerning a procedure must be complied with. And that's where you can nail standing in Congress with that decision, because you can simply state this, what they've pulled, and they violating the constitutional right, the guaranteed liberty interest. Here's where we fight for liberty in the court of justice, right? How we got there is not so much relevant as, oh yeah, we're there, right? And I don't like this any more than you do, because before I was doing this, I was doing a much different form of a job where, oh, that car you're driving and all that equipment you're using, I was the guy who made sure all that crap runs. So if you want me to go back and make sure all that crap runs, you're going to have to kind of help me out here, bro, right? You want to take what we've done and use it for your own benefit, dude. Hey, I have no objection, right? Sure thing. So let's go down to the statutory rule governing procedure. Now, there's a case that Kirk, I know he's watching, Peterson versus Peterson. Believe it or not, you can actually go in and you can actually challenge this procedure, right? Because you're stating by doing what you're doing that these bar actors have torn you into their swamp their court, the process that they did that with is not only not lawful, it's a declared act of tyranny. And the end result is, here's all the crap that I've lost, not just time, more so than just money. How about first moments? You know, missed the first steps, missed shaving, missed the first date, so on and so on and so on and so on, right? So let's just call that spade a spade. So if you want to go down through and you want to challenge this process, here is where you do that, right? You can go through and say, you know, if these guys want to regulate themselves, why are they bothering you? Why are they bothering me? Why are they bothering our tax dollars to do this? Right? They want to go play McDonald's Corporation or Bar Corporation. You do that on your own time. You do that with your own money. Leave us out of it. Leave we the people out of it, right? And that's ultimately speaking where the Peterson versus Peterson case went to, kind of the short version. But because, you know, Kirk explains this much better than I do because he's more passionate about it than I am. I just want to go in there, kick the door open and tell you, hey, dumbass, quit doing it. So, and that's what I'm good at. So, charter provisions governing procedure. This one is important. What are the requirements of a charter, right? These are the things that the charters must be complied with, right? Requirements to charter requirements prescribing the method to be pursued by the municipal body are mandatory. Okay, so let's talk about that. Family court. No prescription or statutory limit runs against a right by blood. So how the hell did you create this thing called family court? How did they sell this to you? So ultimately speaking, your resolution in dealing with the actors in this case also involves a legislative repeal. So it does require an act of Congress. So this is where we go in and we state whether you want to use the Troxel or pick an argument, right? You can pick an argument. Something that the court has already said gives you standing to go and say, look, if I were to go and ask a court or ask the Supreme Court, here's what they're going to say with respect to this subject matter. I don't have to ask them. We don't have to ask them. They already took the liberty of answering that for us. So here you go. Here's their decision, and here's why. So again, this is a not necessarily passing a law, okay, versus a resolution or a repeal. This is why I keep saying, you know, it's like, oh yeah, we need a law for that. We need a law. No. Stop. Time out. Stop. What you need is less, right? You need something that is manageable. You don't need more. You need less. Less is more, right? So, therefore, in so doing this, we want to adopt the rules in governing the procedure of how we go through it, and we actually factor out the stuff that was agreed upon by Congress and the crap that the bar members went in there and overwrote, right, and changed the legislative intent based on the quorum and everything that processed those 10 criteria that we went down. And because these bar actors have done that and perverted the legislative intent and then decided we're going to do it our way anyway, no, you're not. That's a usurpation. And when a long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and provide new guards for their future security. Verbatim from the Declaration. So whether you learn the Declaration by heart the way I did or not, that's up to you. But the point is you need to know what the procedure is, right? And this is why I went through, I wanted to do this real fast and go down through adopting things like an adopted parliamentary authority. What's what's its function? Why is it there, right? Well, E-clause's function is to get rid of all of this crap made up, right? Remove all the bad crap from the record. And that includes the negative conduct, which is what the negative nexus was designed to do, to not only target the negative conduct, but once targeted, go in there and remove it. And, oh, what is negative conduct? That's the Johnson versus Colonial Life and Accident Insurance case that I used as the measuring stick, the barometer, right? If the conduct is consistent with the decision that was made in that case, you can make the decision to take that person and throw them out the door, right? That's what's referred to as a reasonable decision based on what the court's already said. I don't have to ask them about that. We already did that, right? So you don't necessarily need an authority to eliminate something that's not lawful. And I just said, hey, I don't want to talk about just the policy or just the statute. I want to talk about the actual emolument. Why are we spending money on this? Why are we granting it special privileges or gains when we know it isn't lawful? And yes, we already know the answer to that. Just talked about that at the beginning. Agenda 21, 2030, whatever you want to call it. So do we want to keep our republic or don't we? Well, I think it is pretty much a foregone conclusion that since Donald Trump was elected president, whether you like him or whether you hate him, is irrelevant. The fact that he's there is probably a pretty good indicator that we're going to keep our republic. And now this time when we boot the bar out of here, we're going to boot them out of here for good. If somebody wants to business, right, to practice in court and literally drag your happy ass into court or claim they have the authority to do that, we want a mechanism. I said, I'm going to create this thing called E-clause, and I'm going to let you duplicate it. I'm going to leave it bare bones, just me as the CEO, under the corporate rules, under the corporate charter, and we can refine it as we go. Right? This is my service. Provide you guards for our future security. Right? So, that said, if we're going to do it and we want to do it by the numbers and we want to do it properly, if you hire somebody who has businessed themselves, who is purporting themselves to know or practice the law, right? You better be able to make the arguments that your client wants you to make, first of all. The second thing is, I don't want to hear, oh no, I can't make those arguments. Well, if you can't make those arguments, then maybe you're in the wrong house. Maybe you don't need to make those arguments in the court. Maybe you need to make those arguments in Congress. Or how about some form of both? Right? I mean, it is what it is. How we afforded these former attorneys due process through the retasking or redistricting or rebusinessing their bar cards, I really don't care. Point is there's going to be no more layers between layers crap, right? Wrong. Those are bureaucrats. Everybody, whether you're a corporate person or whether you're not a corporate person, freaking hates a bureaucrat because they always have an agenda that is contrary to the common good. We know that throughout history. And again, how much you want to debate that, dude, that's entirely up to you, man. You have at that all you want. So let's go into parliamentary law, okay? Parliamentary law as defined. Parliamentary law consists of the recognized rules, precedents, and usage of legislative and administrative bodies by which their procedure is regulated. It is that system of rules and precedents which originated in the British Parliament, this is the history, and which has been developed by legislative or deliberative bodies in this and other countries, right? So I said, hey, we have a thing called American jurisprudence. Judges have this thing called the canons. Why the hell are they acting outside of those? Oh, well, those are administrative judges. No. That's word salad. A judge is a judge. A judge is a separate entity. They have their own they have their own branch of government. So if you're going to call this somebody sitting in the judge's chair who is purporting themselves as a judge and call them something other than a judge, that is more SMU, because this person is purporting themselves to be something they're not, right? And what would that be? That's an unauthorized practice of law. We can pull that directly from the statute and start using that statute as it was intended to prevent these bar actors from purporting these same declared acts of tyranny, reinstituting themselves with power to investigate or legislate for us in all cases whatsoever. And that's the reason I separated them in list format. So you can go down through that and say, oh, yep, that one looks familiar, that one looks familiar, and that one looks familiar. You know, any one of a number of those could apply to each and every one of your cases. So as far as parliamentary law, not determined by any one legislative body. Okay, this is where oversight comes in. The difference between the oversight process and do we make a law or do we just need a resolution? Okay. Both houses are going to participate in this. Both houses of Congress are going to participate in this process, whether anybody likes it or not. That's the way it's designed, right? So you petition through your House of Representatives and or your Senate, right? Either side can bring forth a petition. It's in their rules. So whichever side you start on is not necessarily relevant. You don't have to have a House member who you get along with, as long as you get along with the senator better. So be it. The senator can take the House member and say, hey, dude, yeah, come on, right? Here's the process, man. We got to follow it, right? Kind of smack him around a little bit behind closed doors and make him do whatever it is he's supposed to be doing. Doesn't have to like it. That's his job. He ran to do the job. Do the job. So that said, we can go down through the rest of this and say, look, okay, under number one, parliamentary law is not determined by the procedure or the rules of any single legislative body. So the oversight committee is an advisory committee, right? They come out, they do their investigation, they do their oversight process, and they bring that out before the body, the actual house that they're in, whether it be the Senate or the House of Representatives or the joint, right? They have joint sessions for a reason. And they can collectively decide based on the issue, subject matter, or whatever that's in front of them to decide what's the best course of action. Well, we already know we're going to need a resolution because there was a trespass, a constitutional trespass. We've got it right here in front of us, right? So that's going to require a resolution. House of Representatives, get to work on that, right? Senate, do we have any bad actors that we need to try? Do we need to impeach them? That we need to hold some form of a contempt action? What process do we need to follow? And that is the process is reserved for the senators and for the congressmen. Our job there is to make the presentation and do it lawfully. So again, let's see, principles. This is another one. I use maxims of law as principles. Parliamentary law is a branch of the common law. So you talk about where do you practice the common law? You practice it in Congress, not court. Most courts don't even recognize common law anymore. If you want to practice in the common law, the Constitution as being the mechanism of the common law, that's in the Congress. That's got nothing to do with the court. The court's already answered questions of law, such as, hey, what does bad actor conduct look like? Okay, that's Johnson versus Colonial Life. Hey, can I claim good faith if I know the action I've taken violates either state or federal law. No, you can't. That's Owen versus City of Independence. This is just us doing our homework, doing our research, and knowing where to put those things in context of our arguments. So, again, parliamentary law is based on principles. It's based on those principles, those fundamental principles, those maxims of law, right? The parliamentary law system of principles is not a group of haphazard rules, right? You don't just take something and, throw it together and say, okay, that's where we're going to call that a thing. No. That's the reason that I created my argument, the negative nexus process, right? That is logical, it's reasonable, it comes from principles and practices of mathematics. It can solve a myriad of difficult issues, a myriad of problems, especially when it relates to the negative conduct that results from not enforcing perjury statutes against government actors, right? Bar members purport themselves to be schooled in the law. Oh, guess what? You're a government actor, whether you like it or not. Why? Because you've got a standing in the court that you claim grants you this privilege, this immunity, right? Well, who ultimately speaking decides who revokes or removes any privilege or immunity? That's Congress. That's why, for example, the treason clause. Let's look at the treason clause. That is written to prohibit anybody but the congressional body from being able to decide what the punishment is for treason. We already know what the crime is, right? I mean, we can go down and argue about the crime all day long. What's the punishment for it? That has to be done through Congress. And again, because I know that there was treason on the court in my case, and the fact I was able to definitively prove it at this point is neither here nor there. The point is now it's proven. It's on the record. And again, another maxim of law. What's on the record ought not be denied. If you walk into court, you can expect they're going to deny you. Know it. Be prepared to deal with it. It is what it is. So, goes back to what I said in the beginning. Knowing that they're going to do that to you, when they do that to you, you take that basic kiss my butt decision that they give you and say, dude, Congress, here's the question I asked and here's what they said, right? I mean, let's just call what's logical and what's reasonable about this, right? These guys have gotten a little bit too big for their britches, don't you think? And how they got there at this point is not even so much as what the cleanup process looks like. Again, my job description. So, the fact that I care? No, I don't care. Somebody has to do the job. So, I'm not going to stand here and just bitch and complain about how screwed up it is. I'm going to apply my skills and my experience to fix that problem. I know what the problem is. Here we go. What's the difference between a public body and a private organization? I said, everybody wants to do nonprofits and kind of blend into this bureaucratic nonsense. I said, you know what? No. I'm going to stand up in the private sector corporations, in government, that's known as the Pentagon, by the way, the defense mechanism, the Department of Defense, and show I'm going to be loud and proud about it. I have nothing to hide. Let these facts be submitted to a candid world. How many times have you heard me say that? Right? So if multiple people happen to benefit from this, oh, well, mission accomplished. That's a good thing. That's what provide for the common defense means. Hang on a second. Okay, sorry about that. Point is let's see, where was I? I hate that damn phone ringing. Let's see. Okay, here we go. Parliamentary law is applied differently to public bodies and to private associations. Okay, I said, look, I don't mind being a private sector person, right? Even though I'm a private sector person, I'll make my issue public. Don't have a problem with that. I have nothing to hide. Okay, so you, Congress, can pick which version of this are we going to apply it as a public body, or are we going to apply it as a private association? I said, okay, I started it as a private sector corporation because I'm saying I'm going to business to provide this service I call loss prevention that I've done for corporations throughout my entire career, whose purpose was to maintain the truth in the record, right? When there's no truth in the record, there's no public trust or consumer confidence in the corporation, right? So now that we can equate those two things as equal, I'm going to show you the benefit, how it protects the integrity of the lawful emoluments, the Congress, right? So here's when they don't enforce perjury statutes, they're literally throwing you under the bus. Oh yeah, I see that, right? So this is what I said. It's just a matter of, me doing what I've always done to, show where the rubber meets the road. Well, I know where the rubber meets the road. That's called emolument. Whether you're on the private side or the public side of it, I don't care. You tell me, where do you want me? You want me over here in the walking the halls of Congress? You want me over there horsing around with Pentagon? I don't care. Some version of both. I don't care. I'll make my reports either way. Doesn't matter. I'm used to that abuse. Trust me. So here's another one. Jurisdictional requirements. What are the requirements for jurisdiction? You want to know what they are? Page 31 of 322. Here is the jurisdictional requirements. Right? That's it right there. I wish it were more complicated than that, but I'm afraid in the end it is just that simple. Right under that, right to act for a body or quorum. Where does that come from? Okay? That starts on page 31 and goes down to, it finishes up on page 32. We talk about majority control. We went through a little bit of that. Delegation of power, right? Why would we want to delegate powers to somebody who doesn't know the subject matter? Again, using my battery example, why would I want to delegate that to a group of hairdressers that know nothing about how to clean up a hazardous materials, clean up a hazmat site where there was lead acid from a car battery, right? That would be the wrong person to delegate that power to, right? We would want somebody who knows how to do that and do that properly. So what is the equity of the members, right? Oh, here we go. Could there be conflicts of interest? See Federal Rule 28C. There's a good one right there. Anybody who has a financial interest, according to Federal Rule of Civil Procedure 28C, anybody who has a financial interest in the particular outcome of the case, technically speaking, doesn't even have standing to be in the room because of that conflict of interest. They cannot remain impartial. This is the problem that I brought up with Title IV et al., right? That promotes a incentive, right? That violates Federal Rule 28C. Again, this is all contained in the documents, and they're posted. It's in the SCOTUS question. But this is where I got this stuff, right? It's where this came from. So there should be a definite rule. If we're going to make a definite decision, with the issue of how we deal with defunct car batteries, right? We need a definite rule on that. That's called, in the private sector, a material and safety data sheet. Okay, so I will be expecting some version of a material safety data sheet to come in the mail or by some other virtue telling me what my scope and authority is. That's called a scope document in this process, right? So use of technical rules being the thing we were just talking about, right? Hazardous material cleanup process. We want to make sure we do that properly. Most direct and simple procedure should be followed, right? Don't make it more complicated than it is. This is where I was going to tell a lot of people, less can be more. -1 times -1 is 1. It doesn't get any more simple than that. One proposition at a time. This is where I tell a lot of people about rambling, right? Focus on where the wheels came off the wagon. What was the incident? What was the date? Who was involved? What has evolved since then is relevant. We get it. We understand that. We need to know where it started. What's the crime scene? That's important. If we don't know what the crime scene is, there's nothing we can clean up. And going into a bunch of rambling doesn't help you. It doesn't help your cause. It sure as hell doesn't help your case. If you want to go through that as some form of therapy, you can list that as a statement of facts, supported by whatever documentation you want to put in the appendix of the document, right? That's one of the reasons why I construct these documents the way I do, is because what supports my claim is all of this crap that has happened since then, right? But I don't spend a lot of time on that. It is what it is. Here's what happened. Here's the document. You want to investigate it further? Have at it. Here's the incident. Here's the document. You want to investigate it further? Have at it. Repeat, rinse, repeat. The immediate pending question. What is the immediate pending question? To me is, what are we going to do now that these emoluments are known definitively to trespass the law, right? What does cleanup look like? That's going to require a pretty good size resolution, don't you think? I mean, let's just call that spade a spade. So precedence of motions. This is where we comes into applying, for example, a case, right? We already know that actors A, B, or C can't claim good faith if the actions that they took violated either state or federal law, right? What version of government they're in is irrelevant. What emolument they hold is irrelevant. The fact is they cannot claim adherence to good faith, which is their binding oath of office, right? That's where they shall be bound thereby. That's why Congress has to remove that privilege or immunity so they can be tried as a mere man or woman. And so on and so on and so on. And Kurt goes into that much more passionately than I do. Applications of one motion to another. Here's where again, the difference between the theory and the practice. How do we apply what we've learned? When do we apply what we've learned? And in what circumstances does flap A fold into slot A, right? Flap B fold into slot B. Sometimes we only need A and C. We might not even need B, right? So it is what it is, whatever it takes to get us there. Your right to debate, where that comes from in the quorum, okay? So you do have a right to debate and participate in the quorum. If you feel the need to point that out, point that out. But in my case, being granted a standing mandate, well, guess what? I don't even have to point that out, right? I have not only the credential that I use to solve this problem, I also now have even the court has kind of backed off and said, okay, you know what, you're right. I need to hear what the hell this loss prevention thing is, because there's a whole lot of torches and pitchforks beating on my door. And yeah, I need to know why the hell they're there. So, interpretation of a member speaking. This is where I always tell you, be very clear. Less can be so much more, right? If you go in and you're rambling, the first thing that these bar members are going to do is they're going to say, you're babbling incoherently. Your arguments are, you're a bumbling idiot, right? Whatever they're going to call you. And believe me, they've got so many crass names for you, you'll never even know half of them. So this is why I tell you, less is more. Speak clearly, speak concisely. When they start that crap, you can look in the quorum, look around the quorum and say, you know, look, there's no need for ambivalence here. That's literally smacking them around with their own allegation. So, again, these are all hints and tips and things that we talk about on the show that I won't go into here. Seconds to motions. Why is that important? You lay a motion down, somebody seconds it. Once it's been seconded, it can be moved to the floor for a vote. So, debatability of motions, we've already discussed that. Amendability of motions, many of you know about how that works. You've been through court process, so you know even how to do that. The finality of an action. Once the action is final, okay, it is what the finality is comes from this section right here. So it goes from what section 65 goes just the bottom of this page 36 of this PDF. Let's see. Can you change an action that is already taken under limited circumstances? Right here, right? Renewal of a motion. So, for example, when I made that declaration for a vote of no confidence, I may want to renew that motion, or somebody may want to renew that motion at some point in time, right? It's there. Don't think it ain't going to come up at some point, because somebody's going to use that. Guaranteed somebody's going to use that. And then we can go into the power of courts with reference to legislative procedure. And this is, I'm going to stop here because technically speaking, they don't have power to do that. So they can participate in the process of telling government what they can't do, or deciding over a capital crime, right? Murder, rape, that kind of thing. So, but as far as the civil process goes, until they're issued a scope document, technically speaking, they don't even have a dog in the fight. So again, this is us learning the process, following due process of law, right? We have to get to where standing goes. We have to assign standing first, right? So once standing has been determined, then we go into the process of the law. I just happen to have a unique approach of targeting stuff that is there that shouldn't be there. Family law is something that's there that shouldn't be there, period. So whether you like that or whether you hate that, I don't care. I know it doesn't belong there. If you have an issue like that, you need to petition the quorum and you need to learn how to do that. Your issue does not affect John Jones, Mary Smith, or, R.J. Smugglenuts for that matter. I mean, your issue is your issue. Handle it and handle it properly. I'll help you learn how to do that, but let's just please be respectful of each other as we go along through the process. Simple request. And on that note, I'm going to jump off of here. I'm going to take this call. And we will see you guys on Wednesday night on Kirk's Law Corner. I believe tomorrow he will be working on doing some basic motion prep for basic, filing notices of appearance, basic memorandums of law, those types of things that you would file into the lower court process. I'm so done horsing around with that I could puke. Because as far as I'm concerned, those things ain't even lawful. Get it the hell out of here. So on that note, stop sharing that. I will see y'all Wednesday night on Kirk's Law Corner, unless, of course, I think of something else to bother you with, to which case I will come out here and bother you then. Much love, everybody. Have a nice weekend. What's left of it.